So Devin Nunes is suing Devin Nunes' mom for defamation?
What a time to be alive.
Viva Frei, Montreal litigator turned YouTuber. I do these things called vlogs, and today we are going to be breaking down and explaining the lawsuit filed by Devin Nunes against a Twitter handle called Devin Nunes' mom, another Twitter handle called Devin Nunes' cow, a Twitter account apparently owned by someone named Elizabeth Mayer, and Twitter themselves. Nunes is suing the defendants for damages resulting from defamation, negligence, fighting words, and we're going to get into that. Now, the law behind this lawsuit is not particularly complex, and the fact pattern itself is not particularly complex either. In a nutshell, one of the defendants, Elizabeth Mayer, who apparently has some sort of communications or opposition research firm, in 2018 embarked on a campaign to destroy Nunes in his re-election bid in his congressional district. Through her account, she posted a slew of what could be considered defamatory tweets containing information, misinformation, slanderous comments as relates to Nunes. Two of the other defendants, who are as of yet unnamed, all we know is the Twitter handle under which they operate, that being Devin Nunes' mom and Devin Nunes' cow, also embarked on the campaign of tweeting and retweeting false, defamatory, erroneous information as relates to Nunes. Twitter, as a defendant, is being sued for negligence for having failed to suspend, ban, penalize, sanction, whatever, these parody accounts which were ostensibly set up for the purposes of abusing and harassing Nunes. That is the overall fact pattern. Now I'm going to walk you through some of the allegations of the lawsuit itself just for greater clarity. And full disclosure, I'm not sure how I feel about this lawsuit either in drafting or in law. I'm not sure what's going to happen with this because I'm not convinced in law it's got the strongest case in the world. We have discussed the criteria for defamation in a number of other videos, so I won't really go into it in greater detail, but I'll post a playlist of the defamation vlogs up here. And while I have my doubts that Nunes is going to succeed on his defamation claim against 3 of the defendants, I think there might be a better chance of his negligence claim against Twitter because Twitter doesn't seem to be enforcing its own rules and policies. But whatever, let's not get ahead of ourselves. Let's start with the lawsuit at page 1. Virginia, in the Circuit Court for the County of Enrico. Plaintiffs, Devin G. Nunes versus Twitter Inc., Elizabeth A. Liz Mayer, Mayer Strategies LLC, Devin Nunes' mom, Devin Nunes' cow.
What a time to be alive.
Plaintiff seeks A. compensatory damages and punitive damages in an amount not less than $250 million. I don't know what's up with this number. This number seems to be floating around as the standard number when suing big corporate entities. You may recall that Nicholas Sandmann is suing CNN and the Washington Post for $250 million as well. B. prejudgment interest on the principal sum awarded by the jury from March 18, 2018 to the date of the judgment at a rate of 6% per year pursuant to sections 801-382 of the Virginia Code as amended. Injunctive relief, and D. court costs. All right, and I suspect the injunctive relief is the C, but it's missing the C and court costs. So that's what plaintiff is suing the defendants for. Now let's get into the allegations of fact. Twitter is an information content provider with a footnote, and let's go see what that footnote says. The term information content provider means any person or entity that is responsible in whole or in part for the creation or development of information provided through the internet or any other interactive computer service. All right, we're going to stop here because I have a short attention span and we are not reading a footnote that constitutes 80% of the words on the page. I read through the footnote. I don't know why the proceeding is drafted this way. The footnote is basically interpretation of various terms in the allegation. If you want to read the entire thing, there's going to be a link for this judgment in the comment section below, and you can freeze frame right now and read the entire thing if you so choose. And then we get to the description of the parties, and I am also not in love with the drafting here. Plaintiff Devin G. Nunes. Nunes, or plaintiff, is a citizen of California. Born October 1, 1973, Nunes has served in the United States House of Representatives since 2003. He currently represents California's 22nd Congressional District, which is located in San Joaquin Valley and includes portions of Tulare and Fresno counties. And the lawsuit goes on for another 2 full pages describing who Nunes is. It really is more of a biography than an allegation, and I'm not saying this to mock or belittle Nunes, full stop. It's just that from a drafting perspective, a 2-page allegation is very hard to digest even for an attorney, but all that to say, it describes in great detail who Nunes is. Paragraph 5 is an important allegation because it's basically going to set out the general context through which the rest of this lawsuit has to be read. In 2018, during his last re-election for the 22nd Congressional District, Nunes endured an orchestrated defamation campaign of stunning breadth and scope, one that no human should ever have to bear and suffer in their whole life. Unlike prior elections where Nunes won by sweeping majorities, Nunes won on November 6, 2018 by a much narrower margin, receiving 52.7% of the 222,379 votes. The malicious, false, and defamatory statements and relentless attacks on Nunes' reputation did not stop after he won the congressional election in 2018. The defamation continues.
It must be stopped.
And then the lawsuit goes on to describe what Twitter is, a publicly traded company with 300 million active users, etc., but we all pretty much know what Twitter is already. At page 7, there's an allegation that is relevant to establishing jurisdiction, which we'll see later on. Twitter is ubiquitous. Twitter is at home in Virginia. Twitter is registered to transact business in Virginia. It maintains a registered office and registered agent in Glen Allen, Virginia. Millions of Virginians have Twitter accounts and use Twitter on a daily basis. Twitter targets Virginians every minute of the day with advertisements of all kinds, earns millions of dollars in revenues from its Virginia source customers. That allegation is specifically made to establish the fact that Virginia is a proper jurisdiction for this lawsuit to be heard. And then we get into describing the other defendants. Defendant Mayer is a citizen of Virginia. She lives and works in Arlington County. Mayer joined Twitter in either 2007 or 2010. She currently operates a Twitter account titled Brand Value $4B with the handle @LizMayer and 37,900 followers. Mayer's Twitter profile discloses that she is a comms strategist, Blunt, Walker, Rand Paul, Perry, Fiorini, former RNC online communications director, Tory, libertarian, Arsenal fan. Mayer claims that she is the US leading right-of-center online communications operative. And this is a critical allegation in fact and in law. On her LinkedIn profile, Mayer admits that, what do I do for these clients? Anonymously smear their opposition on the internet. More broadly, get SH_T done. So bearing in mind that at this stage of the proceedings, this is merely an allegation and not a proven fact, but what we are reading is that Elizabeth Mayer, apparently, her job is to go online and anonymously smear the opposition of other people who mandate her to do so.
And welcome to the beauty of the internet.
And further down the lawsuit, we have the first of multiple examples of the allegedly defamatory tweets made by @LizMayer. I'm not going to read it, but I'll put up a screenshot right now so that you can read it while you listen to my wonderfully soothing voice, saying that I'm not going to read it because I don't want these words to be flagged by YouTube and have this video demonetized. And in paragraph 8, we have an allegation as to why Elizabeth Mayer's company, Mayer Strategies, should also be a defendant. It's pretty self-explanatory, but they are holding the company responsible for the acts of its employee, that being Elizabeth Mayer. And where the allegations get comedically absurd is at paragraph 9 of the lawsuit. Defendant Devin Nunes' mom is a person who, with Twitter's consent, hijacked Nunes' name, falsely impersonated Nunes' mother, and created and maintained an account on Twitter @Devin Nunes Mom for the sole purpose of attacking, defaming, disparaging, and demeaning Nunes. Between February 2018 and March 2019, Twitter allowed Devin Nunes' mom to post hundreds of egregiously false, defamatory, insulting, abusive, hateful, scandalous, and vile statements about Nunes that without question violated Twitter's terms of service and rules, including a seemingly endless series of tweets that falsely accused Nunes of obstruction of justice, perjury, misuse of classified information, and other federal crimes. I'm not going to go through any of them. I'm just going to post a bunch of screenshots right now with suspense strike for each one. And then we get into another apparent member of the Nunes family, Devin Nunes' cow. Defendant, Devin Nunes' cow, a person who, with Twitter's consent, created and maintains an account on Twitter @DevinCow for the sole purpose of attacking and defaming Nunes. Devin Cow has 1,204 followers. How does he get 1,204 followers? That's more than what I have on Twitter. Like Devin Nunes' mom, Devin Nunes' cow engaged in a vicious defamation campaign against Nunes that lasted over a year. Devin Nunes' cow has made, published, and republished hundreds of false and defamatory statements of and concerning Nunes, including the following.
Nunes is a treasonous cowpoke.
And then we see Devin Nunes' cow retweeting tweets from Devin Nunes' grapes. Alright, that is the fact pattern. Apparently, for whatever the reason, Elizabeth Mayer, Devin Nunes' mom, Devin Nunes' cow have it in for Devin Nunes and don't want him to get reelected in 2018. And even after he gets reelected, they continue to post defamatory, insulting, egregiously over-the-top tweets concerning Nunes. And Twitter allegedly allows it. Jurisdiction and venue is going to be important because the defendants apparently made a motion to dismiss for lack of jurisdiction, forum non-convenience, or basically meaning that the forum where the lawsuit was instituted is not the appropriate forum. They sought to have the lawsuit moved from Virginia to the state of California. And the allegations in paragraph 13 and 14 are effectively just allegations to justify the venue that has been chosen by the plaintiff. It is alleged that the defendants are subject to the jurisdiction of the court in Virginia under the Virginia long-arm statute, that the defendants are subject to the general personal jurisdiction in Virginia, that they engage in continuous and systematic business in Virginia, that they all have sufficient contacts with Virginia that the courts have jurisdiction. And ultimately, the motion to dismiss for forum non-convenience was itself dismissed, but we'll get there in a second. So we can see from the allegations that we've gone through that the claim for defamation against 3 of the defendants is relatively straightforward in fact and in law, although I will make a prediction in law at the end of this video. how does Twitter figure into this as a defendant? And to answer that question, we need to go to the allegation contained in paragraph 22, which alleges that Twitter is not respecting or enforcing its own terms of service. Twitter recognizes that it owes a duty of reasonable care to all person who use its platform. In order to protect the experience and safety of people who use Twitter, Twitter imposes limitations on the type of content and behavior that it allows. These limitations are set forth in the Twitter rules. As a general rule, the Twitter rules prohibit use of the platform for, quote, any unlawful purposes or in furtherance of illegal activities. Unlawful purposes and illegal activities include defamation, business disparagement, and insulting words. In order to ensure that people feel safe expressing diverse opinions and beliefs, we prohibit behavior that crosses the line into abuse, including behavior that harasses, intimidates, or uses fear to silence another user's voice. Abuse. You may not engage in the targeted harassment of someone or incite other people to do so. We consider abusive behavior an attempt to harass, intimidate, or silence someone else's voice. And here is an important one in fact and in law. Impersonation. Impersonation. You may not impersonate individuals, groups, or organizations in a manner that is intended to or does mislead, confuse, or deceive others. While you may maintain parody, fan commentary, or newsfeed accounts, you may not do so if the intent of the account is to engage in spamming or abusive behavior. And then the lawsuit connects Twitter's terms of service to the alleged abuse by the other three defendants. At Liz Mayer, at Devin Nunes Mom, at Devin Cow, at Fire Devin Nunes, and at Devin Grape repeatedly tweeted and retweeted abusive and hateful content about Nunes that expressly and undoubtedly violated Twitter's terms and rules. And then the lawsuit goes on to allege that Twitter did absolutely nothing to enforce its own terms and rules as relates to the conduct of the other three defendants. And according to the allegations, to make matters even worse, at paragraph 30 it is alleged that Twitter actually shadow banned Nunes himself. Now, I actually tweeted at Devin Nunes to ask him how he knew that he was shadow banned, because it's not always easy to know if you are shadow banned on any platform. But because I am an absolute nobody, I did not get a response from Devin Nunes, but maybe, just maybe, he will respond to this video and further allege how he knew that he was shadow banned and what Twitter's justification was for that shadow banning. And at paragraphs 33 and following, we have the allegations as to the negligence of Twitter and why they should be held responsible. Twitter used its platform and allowed its platform to be used by others as a means to defame Nunes. Twitter failed to take action to enforce its terms and rules in the face of known abusive behavior and failed to reasonably monitor and police the platform to ensure that rampant abuse and defamation was not occurring. As a direct and proximate result of Twitter's negligence, Nunes suffered actual damages in the amount of $250 million, including pain, insult, embarrassment, humiliation, emotional distress, and mental suffering, and injury to his personal and professional reputations. Paragraphs 39 and following relate to the alleged defamation committed by the other three defendants, and without going into detail about defamation in and of itself, because I've already done a few videos on it, suffice to say that they are alleging actual malice by the defendants, which is required in law when the defamation relates to public figures. Nunes is undoubtedly a public figure, and in his capacity as a public figure, in order to prove defamation, he's going to have to prove not only the defamation, but that the statements were made with actual malice. Whereas actual malice is not required when the plaintiff is a private citizen or non-public figure. But I was particularly interested in the allegations at paragraph 49 and count 3.
Insulting words.
Plaintiff restates paragraphs 1 through 48 of his complaint and incorporates them herein by reference. Defendants' insulting words in the context and under the circumstances in which they were written and tweeted tend to violence and breach of the peace. Like any reasonable persons, Nunes was humiliated, disgusted, angered, and provoked by the defendant's insulting words. Defendants' words are fighting words, which are actionable under section 801-45 of the Virginia Code 1950 as amended. Fighting words. Them's fighting words.
Hey you, let's fight. Them's fighting words.
I always said this growing up. I learned so much from The Simpsons that I never even knew that I was learning. I learned Virginia Code from The Simpsons. But this is a very interesting header of damage and really perfectly explains why plaintiff wants Virginia as the jurisdiction for this lawsuit. And at paragraphs 54 and following, we have count 4, common law conspiracy. Paragraph 55, the defendants acted intentionally, purposefully, without lawful justification, and with the express knowledge that they were defaming Nunes. Paragraph 58, count 5, we have an injunction. Nunes wants the names of the account holders of Devin Nunes' mom and Devin Nunes' cow, and Nunes wants a permanent injunction enjoining Twitter to suspend the accounts of the other defendants and remove the hyperlinks to their allegedly defamatory tweets. Alright, and that is the lawsuit. Now, I mentioned this earlier, but the defendants made a motion to dismiss without prejudice for forum nonconvenience, lack of jurisdiction of the Virginia courts. They sought the transfer of the lawsuit from Virginia to California. The arguments were that the defendants now reside in California, Twitter resides in California, the servers reside in California, basically everything is in California. And without getting into the nitty-gritty of the 8-page judgment, suffice to say that the motion to dismiss dismiss was not granted. The judge concluded that the defamation occurred in Virginia, that the defendant resided in Virginia at relevant times, and that as such, Virginia has jurisdiction to hear the lawsuit. And from what I understand, the defendants might also now make a motion to dismiss for failure to state a claim. And those are two different legal bases for making a motion to dismiss. One is that the court doesn't even have jurisdiction to hear the lawsuit. And we can easily imagine why the defendants made this motion to transfer jurisdiction to California. First of all, I guess the general consensus is that if you're in California, you might get a more favorable jury to hear the case. Because after all, there is a request for trial by jury in this lawsuit. The applicable law would also be different. Nunes would have to rely on different law and could no longer invoke or rely on this Virginia statute prohibiting
Fighting words.
So why the defendants would want a change of jurisdiction is strategically pretty obvious. Why they went with a motion to dismiss for lack of jurisdiction before a motion to dismiss for failure to state a claim is also strategically pretty obvious. The main reason is that if the court lacks jurisdiction to hear the case, it doesn't even have jurisdiction to dismiss the case for failure to state a claim. The defendants need to present that motion to dismiss for failure to state a claim before the court that has proper jurisdiction. So the argument is, let's seek to have this case dismissed for lack of jurisdiction, get in front of a California court, and then make our motion to dismiss for failure to state a claim before a court that might be even more favorable in terms of granting such a motion to dismiss for failure to state a claim. As it is now, because the motion to dismiss for improper jurisdiction was dismissed, they are going to be stuck making that motion to dismiss for failure to state a claim before the Virginia court. Alright, so that is the strategy behind the motion to dismiss and where the file is right now. And what do I think about the substance of this lawsuit? It's very interesting because the Twitter rules prohibit accounts that are intended to impersonate other people, but they permit parody accounts. They prohibit targeted harassment, but they allow for commentary. So the real question in fact and in law, at least with respect to Devin Nunes' mom and Devin Nunes' cow accounts, is anyone going to actually reasonably believe that these are impersonating real people? Is anyone going to actually think that Devin Nunes' mom's Twitter account is actually Devin Nunes' mom? As relates to defamation, is anyone going to even really take anything seriously that comes out of an account called Devin Nunes' mom or Devin Nunes' cow? Now I appreciate that the situation might be a little different for Liz Mayer's account, which ostensibly looks like a legitimate or non-parody account. And so people might take what comes out of that account with a little more credibility than tweets coming from Devin Nunes' mom, Devin Nunes' grapes, or Devin Nunes' cow. It may be all the mean things in the world, but as relates to these types of accounts and public officials, especially those running for office, when does it cross the line from commentary or parody to unlawful or illegal harassment or defamation? As relates to at least 3 of the defendants, that is going to be the question in fact and in law that is going to have to be adjudicated on. It gets a little more complicated as relates to Twitter because Twitter has terms of service and rules, and if it doesn't enforce those rules, does it become legally liable for the damages resulting from not enforcing its own rules? It has duties towards its users, and if it fails in those duties, does it incur its own liability vis-a-vis those harmed users? But ultimately, Nunes is a public official running for office. And although it is disgusting, it is to be expected when anyone runs for office that you are going to have people doing this type of stuff. And this lawsuit highlights the strategic risks of filing this type of lawsuit. Because whereas before you might have only had a handful of Dennis Nunes moms or Dennis Nunes cow accounts, I went on Twitter earlier today and I found dozens of these types of parody accounts. I see Devin Nunes' conscience. Devin Nunes has negative IQ. Dennis Nunes, first grade teacher. This reminds me of that Microsoft lawsuit where they sued Microsoft over the domain name, and in so doing, overnight had dozens of other people buy up every other variation of Microsoft web names that they could get their hands on. I do suspect that this lawsuit is less about winning on the merits than it is about learning how Twitter enforces its own rules, which will presumably be very discoverable when Nunes gets to discover representatives of Twitter. But ultimately, sometimes filing a lawsuit actually exacerbates the problem and makes it 10 times worse. It becomes something of a meme, and people who never had this idea in the first place are now going to go out and try to create all sorts of fake Twitter handles using variations of Devin Nunes and random objects, people, and animals. But that is it. That is where it stands right now. If you like my content, be sure to like, share, subscribe, hit the notification bell, drop a comment in the comment section below. Let me know what you think is going to happen with this lawsuit and how you feel about this lawsuit. And as always, if you want to support my channel, there's a PayPal link up in the banner. I'll put a link down in the comment section below. If you want some merch, I'll post the link in the comment section in the pinned comment. And now you know your vlog. Peace out. Booyah! And I realize I forgot to give my formal prediction. My formal prediction is that Nunes is going to succeed on his defamation claim in part against Elizabeth Mayer. He is going to fail on his defamation claim against Devin Nunes' mom and Devin Nunes' cow. And he will succeed in part for his claim of negligence against Twitter for failure to enforce its own rules. That said, I am batting 0 for 1 on my prediction for Nicholas Sandmann, so take it for what it's worth.